안녕하세요. Hello, my name is Eric Chan, and I'm a partner at ShookLin&Bok, a Singapore law firm. I head the financial services regulation practice in ShookLin&Bok, and today it is my pleasure to deliver to you a short presentational overview of the regulation of cryptocurrencies in Singapore. Before I begin, there will have to be the usual disclaimers. So this presentation is really only for information. It should not be regarded as legal or professional advice. It is not intended to be comprehensive, and therefore, if you have a specific situation where you think you need legal advice, please do not hesitate to contact us. I start off with an introduction on where Singapore is with respect to cryptocurrency. Within traditional legal jurisprudence, cryptocurrency is a strange and bizarre creature. In a sense, it's not like any form of asset that you have encountered before. So the immediate question is, what would be its legal nature? In substance, of course, cryptocurrencies are electronic assets which are held on an open source peer-to-peer network. They may have a value, but they have no innate value as such. So the value that they have is essentially what the marketplace ascribes to it. Cryptocurrencies also do not necessarily have predefined rights and obligations. Some may have rights and obligations, some do not. And even where they do provide for rights and functionalities, it is not very clear that they are necessarily enforceable before a court of law. Among other considerations, there will also be questions relating to property law, for example, whether it can be owned, whether it can be possessed, and whether it can be transferred. Singapore law, common law, basically recognizes the concept of different types of property, and one classification is between tangible property, things that are physical in nature, which can therefore be possessed and which can therefore be stolen. And on the other hand, there will be what we call intangible property, which do not take a material form and therefore technically cannot be possessed, nor can it be stolen. Because cryptocurrencies are not tangible in nature, one would think that it could be considered intangible property. However, common law also recognizes a third category, and this is what we call documentary intangibles. Documentary intangibles are actually intangible assets, but they are encapsulated in a documentary form. And because they are encapsulated in a documentary form, they can actually be possessed, and therefore they can be stolen. So the law basically considers these sort of documentary intangibles to be what we call choses in possession, as opposed to contractual rights, which are purely intangible and which are not encapsulated. Those tend to be called choses in action. As to whether cryptocurrencies are choses in action or choses in possession, that remains unclear. In Singapore, the nature of cryptocurrency as a property has been considered by our courts. In a decision made last year in the case called Coin Private Limited versus B2C Limited, the Singapore Court of Appeal recognized that cryptocurrency can be treated as property. And this is what the court said. There may be much to commend the view that cryptocurrency should be capable of assimilation into the general concepts of property. There are, however, difficult questions as to the type of property that is involved. It is not necessary for us to come to a final position on this question in the present case. So, in a sense, the court basically recognized that cryptocurrency ought to be considered as property, but the court declined to express a final view as to the particular type of property it is to be classified as. In the next few slides, I'm going to take you through a short history of cryptocurrency in Singapore. The history really starts in 2017, in the early part of 2017, when ICOs or initial coin offerings began to gain prominence in Singapore as well as all over the world. By mid-2017, the popularity of Singapore as an ICO originating country has begun to peak. To the point that a couple of months later, in August 2017, the MAS began to issue a warning concerning ICOs. This finally, matters really came to a head when the issue even emerged in Parliament, and this prompted the chairman of the MAS, then Deputy Prime Minister Tharman Shanmugaratnam, to actually have to make a statement in Parliament concerning ICOs. And in Parliament, the Deputy Prime Minister basically said that the MAS was monitoring the situation very, very closely and would take action if necessary. In November, the MAS finally took some action in the form of issuing a guidance on digital token offerings. In this guidance, the MAS basically emphasized that certain digital token offerings could actually be regulated because these tokens would have features that make it a security and therefore brought it within the framework of Singapore's security laws. In the same month, the MAS also issued a consultation paper relating to a new proposed legislation for payment services. And in that proposal, it was indicated for the first time that entities that deal in virtual currencies would also be subject to regulation under the new legislation. This new legislation became the Payment Services Act. It was eventually enacted, rather it was passed by Parliament in January 2019. As mentioned, it provides for the regulation of intermediaries that provide digital payment token services. The terminology changed a little bit between 2017 and 2019. And eventually in January 2020, less than just about a year ago, the Payment Services Act finally came into legal effect. In the next couple of slides, I'm going to highlight a few of the critical press releases that was issued in the light of all the frenzy over ICOs. The first important press release was dated August 2017. In this press release, the MAS clarified that the offer of certain types of digital tokens will be subject to regulation if the tokens constituted products that came within the SFA, the Securities and Futures Act. The MAS clarification came in the wake of a recent increase in the number of ICOs in Singapore. About a year later, things have now evolved to the stage where digital token exchanges were now quite popular. These are basically platforms, typically online, that basically allow trading of different types of digital tokens. Sometimes you can trade one token for another token. Other occasions, you can actually convert from cash to token and vice versa. Okay. In this case, the MAS had warned 8 digital tokens that were operating in Singapore. And the MAS said that, well, they shouldn't allow trading in these tokens if these tokens constituted securities or futures, because this would then be regulated products. In addition, in May 2018, the MAS also issued a warning to tell a proposed ICO issuer to stop the offering of digital tokens, again, because this particular token was considered by MAS to be a security. The frenzy really continued into 2019, and in this particular case, the MAS again warned an ICO issuer not to proceed until it could comply with its obligations under the SFA. Again, the MAS took the opportunity to remind consumers at large to understand the benefits and risks of such products before committing to an investment. I now move on to discuss how the cryptocurrencies are actually treated under the current regulatory framework. As mentioned earlier, there are 2 broad regulatory frameworks that could potentially apply. First of all, there is the Capital Markets Regulatory Framework established by 2 related legislation, the Securities and Futures Act and the Financial Advisors Act. Here, if the token has features that makes it either a capital markets product or an investment product, then licensing under either the SFA or the FAA is potentially required. Of course, there will be exceptions. Apart from licensing of the intermediary that will deal in the token, if there is going to be a public offer of the token to persons in Singapore, then the SFA Part 13 rules, these are rules relating to disclosure documents and the filing of a prospectus. These rules are also potentially relevant, and it is necessary to comply unless, again, there is an exception that can be relied upon. Then, assuming that the token is not a security or a capital markets product, the other question would be whether it constitutes a digital payment token, because under the Payment Services Act, a person who deals in digital payment tokens will be required to be licensed under Part 2 of that Act. Let me perhaps jump a little bit deeper into the capital markets regulatory regime. Now, the terminology used in the SFA and FAA are consistent, and basically the 2 important terms to note is capital markets product and investment products. Capital markets products are basically these 4 types of products: securities like shares and bonds, units in collective investment schemes, which are basically units in your mutual funds, derivative contracts, and leveraged spot FX contracts. Okay, investment products are slightly wider. So the term investment products includes all of the aforesaid capital markets products plus unleveraged spot FX contracts are also considered to be investment products, and life insurance policies are also considered to be investment products. So entities that deal in either of these are required to be licensed or at least operate under an exemption under these two legislation. So, as far as determining whether the capital markets regulatory framework applies or not, the immediate question is to look at the crypto asset and ask yourself if it has features that make it a product that is within the scope of the SFA or the FAA. If no, well and good. If yes, then you need to consider two potential groups of rules. Firstly, the SFA licensing rules under Part 4 or the FAA licensing rules could apply to the intermediary that actually deals with the crypto asset. And furthermore, if there is going to be a public offer, then the SFA Part 13 prospectus rules may have to apply. Right, I now move on to talk about the Payment Services Act. Now, Payment Services Act provides for licensing of payment services providers. So the basic rule is that a person must not carry on a business of providing any payment service unless he has a license or is exempt. In this regard, payment services include digital payment token services, so DPT services for short. What are DPT service? What are the payment services? Well, there are actually 7 categories of payment services licensable under Part 2 of the PSA. Of course, the one that we are concerned about is DPT services. Okay, what's a DPT? What's a digital payment token? A digital payment token is defined as follows in the PSA. First of all, it has to be a digital representation of value. Okay, it's as a digital representation of value. Secondly, it has to be expressed as a unit. So there must be a certain number. It must be a quantifiable. So there must be 1 token, 2 token, etc. Thirdly, it cannot be denominated nor pegged to any particular currency. So you actually do not associate it with a particular dollar value or sterling or pound or yen or whatever. Okay. It must also be intended or used as a medium exchange. So you can use it to pay for goods, use it to pay for services, or to pay off debts. And it must also be transferable, storable, or tradable electronically. So the definition you can see is actually quite wide. As a matter of information, a couple of weeks ago, the Singapore Parliament also approved of certain changes that would be made to the PSA, particularly to expand the scope of the notion of DPT services. Now, these amendments have been passed by Parliament, but they have not come into force yet, but we do expect that it will come into force quite quickly. So what is DPT services? Currently, DPT services only means the first 2 items, the service of dealing in DPTs, as in buying and selling DPTs. Secondly, the service of facilitating the exchange of DPTs from one form to another or from a DPT into cash. With the amendments taking effect, additional categories of DPT services will be included. Firstly, the service of accepting DPTs from one account to be transmitted to another account is now going to be considered as DPT services. Please note that in this regard, it is not necessary for an entity to actually possess. Well, in this case, it's actually necessary for them to possess, but for the next couple of transactions, arranging transmission, inducing transactions, in these 2 cases, it is not actually necessary for the service provider to physically possess the DPTs or to hold the DPTs itself. Okay, then safeguarding DPTs, in other words, acting as a custodian, that's going to be considered to be a DPT service. Carrying out instructions for a customer in relation to DPT, that's going to be considered a DPT service. Again, in this case, the entity may not necessarily have custody of the DPT. And finally, the last two concerns safeguarding or carrying out instructions relating to DPT instruments. DPT instruments is a new concept. Basically, it refers not to the DPT itself, not to the token itself, but it refers to things that enable one to gain access to a token. For example, passcodes, passwords, etc., that basically enable a person to get access to the token itself. So in summary, you see that currently there are only two classes of DPT services: dealing, buying and selling, and exchanging, but with possession. With the amendments, there will be additional categories. So there are in fact 7 categories, but I've basically grouped them into 4 circles. So you have safeguard and custody, inducing transactions, arranging transmission, and accepting for transmission. Okay, assuming that you do need licensing, the PSA operates on a tiered system. The first tier is only for money changing, but the second and third tiers are potentially relevant for entities that want to deal in cryptocurrency. So the second tier is basically what we call an SPI license, a standard payment institution license. Here, the licensing is subject to the condition that the entity must operate within a certain level of business volumes. So this depends on how many services you provide. If you're only offering one service, so if you're offering DPT alone, then the total transaction value is $3 million or less. And this is calculated on an average basis over 1 calendar year. However, if you're also offering 2 or more services, then the threshold becomes 6 million or less. And if you're dealing in e-money, okay, then you also have an additional restriction of an average daily float, again measured over a calendar year of 5 million. Okay, so SPI entities are basically subject to a minimum base capital requirement of Singapore dollars 100,000. So this has to be your paid up capital. If these restrictions are going to be too problematic, then the solution is to really go for an MPI license. An MPI license doesn't have any business restrictions in terms of transaction flows or thresholds, but you do have a much higher base capital of $250,000. In addition, you might need to put in a security deposit of at least $100,000 or $200,000. And of course, MPIs are subjected to more rigorous regulation. There are more rules and conduct restrictions that must be observed. This slide basically summarizes the regulatory content under the PSA. So for payments, for DPT services, at the moment, the content of regulation is mainly to prevent money laundering and terrorism financing. However, under the new framework, MES will have powers to impose various user protection measures on a service provider engaged in DPT services. So let me talk a little bit about anti-money laundering. The anti-money laundering rules for DPT service providers is set out in this notice called MES Notice PSNO2. Okay, so the overarching requirement is, of course, that the entity must always conduct enterprise-wide risk management. It must look at the clients it serves, the types of transactions, etc., to make sure that the risk of money laundering or terrorism financing are properly managed and that it has appropriate controls that deals with this risk. When it onboards clients, of course, it must undertake customer due diligence. So customer due diligence basically comprises of identifying customers, checking their identities, etc., identifying beneficial owners, persons who may control the customer, and as well as understanding the purpose of the relationship, like what's the purpose of the account being opened for investments, for speculation, etc. This sort of information enables the entity, the service provider, to build up a profile of the client so that it can then from there detect what would be unusual or abnormal behavior. And if this unusual or abnormal behavior is cause for concern, then the obligation under money laundering law is to report these as suspicious transactions to the authorities. This is a new rule. These are the new requirements that MES may impose on DPT service providers once the amendments to the PSA kicks in. In essence, there are various things that MES is now further able to impose. It could impose requirements relating to the extent to which customer assets can be mixed up with the entity's own assets. It can impose requirements binding the service provider to hold a certain percentage of his own assets in liquid form, for example, in cash or in government securities. This is to ensure that it has appropriate liquidity. It can impose rules relating to custody of customer assets. So rather than to hold the assets in its own books, the service provider could potentially be required to custodize the customer assets with a third party. There could be obligations relating to certain dealings, like certain contractual terms with customers and certain mandatory disclosures that are to be made to customers. And generally, there are also the ability of the MAS to impose other operational and business conduct restrictions. These will all be set out in regulations. So that really wraps up all I have to say largely. I just want to perhaps mention one other thing, and these are the MES Guide to Digital Token Offerings. I mentioned this. This was first issued in November 2017. It has since been revised. The latest version is dated 26 May 2020. What is very important about these guidelines is that they contain a series of case study illustrations that show how Singapore's regulatory laws may potentially apply. And so if you're really contemplating offering or operating or dealing in cryptocurrencies in Singapore, you should definitely refer to this guide to consider, to know where you stand with current Singapore law. And if you have problems, then of course the solution is to either consult legal advisors or to engage with MES to get clarity. So that's all I have to say. Thank you very much for your attention. I hope this gives you a good indication of the position in Singapore. Thank you and goodbye. 감사합니다. 안녕히 계세요.